everyone. Thanks so much for being here at the last session of the day. I'm actually very pleased by this turnout, so props to you guys for hanging on. Hopefully you'll learn something today. We have 18 minutes, so it's not a lot of time, but I hear I have a little bit of leeway, and hopefully we can use that time for some good question and answer. What I'm going to try to do in today's session is give you a snapshot, an overview in 18 minutes of how you're going to manage your legal risk, whether you're an advertiser, a network, or an affiliate, anyone in the chain of command in the affiliate marketing world. But before I do so, let me just introduce myself. My name is Rachel Hirsch. I'm an attorney at the Washington, D.C.-based law firm of Ifrah, PLLC. We're all big firm lawyers. We started the firm 5.5 years ago and been to the show now, our 10th time at the show. So we host that Power Booth station where you charge your phones, and I hope you all had a chance to stop by and say hello. What we do is we focus our practice on compliance and litigation work for online marketers. So we are very savvy on what it takes to stay out of trouble because we handle a lot of FTC litigation, private class action work, and we want to make sure that you are successful in the long term. And to do so, you have to manage your legal risk because you never want to be in a position where you're in the defensive posture. You want to always make sure that you have processes and procedures in place so that you're ahead of time so that you're not getting into trouble. And should you get into trouble, you can always go back and rely on those processes and procedures to show that you manage your risk in a way that shifts liability to somebody else or takes the pressure off of you. So in the affiliate world, managing risk means controlling both the medium and the messenger. So what is your message? How is it communicated? And who is doing that communication on your behalf? So I'm going to go really quickly in high-level view of the certain areas of communication that you have to be aware of. So understanding legal risk really means understanding your medium of communication. What is it that regulators and private class action citizens are looking at to point the finger at you and scrutinize your behaviors? So I've listed here the most popular forms of marketing that we see. Obviously, there's others, but I'm going to start with email marketing, which is probably the cheapest and easiest form of marketing because there's high returns and high volume and you can do it quickly. When you're dealing with email marketing, of course, you need to be sensitive of the CAN-SPAM laws and being sensitive of not sending out unsolicited commercial messages to consumers. So the question becomes, what's a commercial message? A commercial message in its simplistic form is when you're trying to advertise or sell something. So if you're trying to sell something, you need to make sure that you have permission from that consumer to send them that message. So how do you stay compliant in the email marketing world? So first you have to deal with the very basics, your header information, your from, to, reply, and routing information. So you need to including the original domain and email address. It has to be accurate and identify the person or business who's initiating the message. You can use a DBA kind of name, but it has to be an actual company that you can be contacted at. Don't use deceptive subject lines. Make sure your subject line doesn't say free gift card, but you're really selling something else. That's probably the most basic form of how to be compliant with CAN-SPAM laws. Then again, identify the message as an ad. Tell them that you are selling something, that this is an advertisement, unless, of course, you have permission ahead of time from the recipient, having had affirmatively opted into receiving these messages. The other thing you need to do is let them know where you're located. Give them a real business address, a mailing form. It could be a P.O. box, but you have to give them a way of contacting you by physical address so they know that you're a real company. And then, of course, tell them how to opt out of receiving future emails. So including an opt-out notice at the end or giving a return email address, and then making sure you keep up your email list of people who have opted out so that you don't contact them again. The next medium of communication we have is phone calls and text messages, and that falls under the category of the Telephone Consumer Protection Act, making sure you're not sending unsolicited calls or texts to people who have not opted into receiving those messages. In October 2013, there were some rule changes to the TCPA, which has been around since 1991, but people got all in a panic about, can I call this person? How do I do it? And the rule changes really just kind of clarified and created a little bit more stricter standards of what you need to do. So again, in a nutshell, let me just tell you what those rule changes were. So if you're dealing with calls made to mobile phones, The marketer must receive prior express written consent from the consumer before placing what are called auto-dialed calls or texts or generating pre-recorded messages to cell phones for telemarketing purposes. So you have to look at what the purpose of the call is. Is it telemarketing? What kind of recipient is it? Is it a cell phone or a landline? And how is it generated? Are you using something that's an auto-dialer or has a capacity to be an auto-dialer? So of course there's exceptions. The exceptions are live non-auto-dialer telemarketing calls to wireless numbers do not require prior consent, and live non-auto-dialer informational calls to wireless numbers also do not require consent. Then if you're calling landlines, which who has a landline these days, you have to obtain prior express written consent before generating pre-recorded telephone calls or to consumer landlines for telemarketing purposes. The exceptions to that in very general terms are live telemarketing calls with or without an auto dialer to residential lines don't require prior consent, and live informational calls about charities and such with or without auto dialers also do not require consent. Mobile advertising. Biggest issue with mobile advertising is how do you fit your disclosures onto that little space? So now I'm going to talk a little bit more about where you're supposed to have your disclosures and what's required of you. But in mobile, the rule is if you can't fit it on there, then don't make the claim or don't make the statement. And that's really how the FTC views it, is if you can't say it in short, abbreviated terms, then don't say it at all. And those rule changes really came into effect with the revised .com disclosures that the FTC issued in 2013. So really, when you're dealing with mobile advertising, you need to be aware of short and abbreviated disclosures, whether they adequately inform the consumer of the essence of the required disclosure, what technological limitations you have, like browser types or pop-up blockers that may affect your disclosures, and how close to the actual claim you can make that disclosure. The next form of marketing that's important to understand how you control the medium is social media and blogs, which were also included in the updated revised disclosure guidelines that the FTC issued in 2013. So the big thing we have is, for instance, paid tweets. You have someone endorsing your company through a tweet. You need to disclose in the tweet that you're paid. So how do you do that? Maybe you do hashtag sponsor tweet, or you do hashtag ad. So for example, here's an example I've used before. Shooting a celebrity is promoting a weight loss product. She'll say, shooting movie beach scene, had to lose 30 pounds in 6 weeks. Thanks, Fat Away Pills, for making it easy. And then it says hashtag ad. Of course, again, with tweets, you have very limited characters, and you also have to get in any disclosures or disclaimers you need. So for example, in that scenario, you have to say what the typical weight loss would be for the average consumer. So that's a lot of words to get in. It's like my 18-minute speech. A lot of words to get in a very limited amount of time. So those are things that you need to be aware of. And this is really becoming more popular in terms of enforcement. We've seen a lot of warning letters, but not a lot of litigation yet in that space. But we're going to see more as people understand what these revised disclosure guidelines are about. We had this Cole Haan case, if you all may have heard of, where Cole Haan was telling people to take pictures of them walking in their shoes and post it, and then one person would win a prize. And the FTC sent them a letter and said that you need to disclose that that's an ad, even though not everyone won something. But they didn't pursue anything further because the disclosure guidelines were so new and there wasn't really much precedent for it. So they kind of just warned them, and that's what happened there. Last but not least, our favorite advertorial landing pages. This is, your typical, lose weight in 30 days or whatever it may be. But 3 things to keep in mind here, if I could abbreviate. Advertising must be truthful and misleading. That's true in any form of communication, but really, when you're having these landing pages, that's key. Don't make claims that require proof you don't have. I can't tell you how many people have made claims that are outlandish, and then the FTC or someone comes up to them and says, prove it. Can't do it. I copied that from somebody else's page, And also, you can't make unfair statements, something that would be perceived by a consumer to be misleading or unfair. Those are the general things you need to keep in mind with advertorials. And that really comes into play with, these fake news sites, when people think these news sites are, promoting a product as an independent review, but really they're a landing page meant to generate leads to a sales page. And that's been the real enforcement effort from the FTC, is cracking down on these so-called fake news sites. So we talked about before is controlling your means of communication. So the FTC had this new operation. They love to name them really fun names. Operation Full Disclosure. Not about some guy flashing you in a trench coat, but really they want to know where you place your disclosures and what constitutes an adequate disclosure. So they have certain principles that you need to keep in mind when you are making certain disclosures. So placement and proximity. How close to the claim is the disclosure? Prominence. How clear is it? Can you see it? Is it like in 6-point font, on a page that otherwise has 48-point font? That's not going to be prominent. Unavoidability. Is there graphics or text or something that's taking away from seeing that disclosure that would distract the user from the disclosure? Again, that also goes with distracting factors. You can't have it like popping up here and there and then disappearing, or having graphics overlay it. It really needs to be clear. Repetition. Disclose and disclose often. If you're making a claim more than once, every time you make that claim, disclose that the typical weight loss is 1 pound per week, or average consumers tend to see this type of result using this type of product. Duration of the disclosure, that comes up a lot in mobile advertising and things that pass through, like things that you see quickly. How long do you see that disclosure? Understandability. If you're marketing to Spanish-speaking clients, are you making a disclosure in English? That has to be understandable in the language to the consumers that you are marketing to. And format and language. Same thing, it kind of falls into the same category, is making sure that you're using proper language that appeals to the right audience. So there's some examples we have of communications that are considered inadequate. So failure to disclose pricing conditions. You're having a trial offer, you don't know that's a trial offer, you're signing someone up for a negative option offer, and they don't know it, and they're getting billed every single month. Big no-no. We have the FTC cases right now going on that I'm handling, where that's a big issue right now, and they're really trying to crack down on that. Same thing that falls in the second area too, is disclose automatic billing features. Anytime you're charging someone and they may not be aware of that charge, that's going to be something that's going to subject you to scrutiny. Claiming your product's capabilities or superiority without substantiation. Better than Botox. How are you going to prove it? You tested your product against Botox? It's probably not better than Botox. Don't make that claim. You're not going to be able to substantiate it. Promoting risk-free or worry-free trial periods without disclosing additional costs. If you're going to be in a negative option, that's not risk-free. There's always risk involved because you're going to get charged. And then making broad claims without limitations or qualifications. You always have to say, even if you're making a claim about a health claim, and you're using a doctor, you have to show the fact that he's qualified in certain areas and he's not qualified to opine about others. So if you're using a doctor in a diet ad who's, an internist, they may not be specialized to talk about diet stuff. Or if you're talking about a cardiologist who's making diet claims, you have to disclose the fact that they're a cardiologist and not someone who does nutrition or dietary work on a regular basis. So now we're looking at controlling the messenger. So now you know what the message is, you know how the medium is and how to control it, but you really need to understand who's sending this message on your behalf. So this slide is geared toward networks and affiliates dealing with the advertiser. Here, the advertiser is the messenger. The advertiser is controlling the message, telling you what to say. So here I put some few tips of how to deal with this scenario. So first rule of thumb for everyone is never work with an advertiser without a contract. Don't send me these half-page IOs. They don't cover anything. I don't want to see those things, and then you get into an argument, and you didn't get paid, or you're left holding the bill, or you're left holding the bag with liability. You need a good contract. And certain things that need to be in every contract. Compensation determination. How are you being compensated? Is it per click, per lead, per sale, per action? What qualifies as a lead? What are your lists of responsibilities? What representations and warranties are you making? Who's responsible for what? What's the governing law? If you're going to sue them, where do you have to sue them, or where are you going to be sued? Are there dispute resolution clauses? Do you have to go to arbitration, or can you go straight to court? Termination provisions. Can you terminate at will, or you have to give notice? And of course, indemnification. Who is going to be responsible and pay for your costs if you're brought into litigation? Again, when you're determining bargaining power is very important, because as an affiliate, you often don't have bargaining power to negotiate an advertiser agreement. They'll usually give you a standard agreement and make you sign it. But sometimes networks and affiliates bring a lot of money in for the advertiser, and they can propose changes. If you can do so, bargain for it, because you don't want to accept anything that's a standard agreement. Also, institute best practices and hold your advertisers accountable. If they're giving you creatives and if they're giving you things that are not acceptable in your network that have claims, make sure you tell them you can't accept that and you expect them to go through legal and make changes. Maintain good record keeping. Always keep your email communications with them. Everything has to be in writing. Don't just do phone calls because you want proof if it comes down to who is responsible for an ad. And then, of course, limit your liability, going back to the indemnification. What if the affiliate or the publisher is a messenger? As an advertiser, what are some best practices to control what they say? Same principle, never work with an affiliate without a contract. They're going to be the ones who are going to try to make as much money as possible, making as many outlandish claims as possible. You need to know what they're doing, and you need to hold them accountable. And doing that contractually is one way of doing so. Also, institute best practices. These are the kind of claims you can make. You can't use creatives unless we've approved them. You can't, you can't send leads to these types of people. You have to always qualify what they can and cannot do. You also want to conduct periodic audits, but not micromanage what they're doing, because you want to have some oversight, because you can't turn a blind eye, but you also don't want to be responsible for every little thing they do, because if someone comes to you and says, why did you do this, like a government agency, you could say, it wasn't me, it was my affiliate, and I check on them every month, every 3 months, whatever, and I had no idea, and I terminated them once I found out they were doing this behavior. Another reason to maintain good record keeping. If you send them an email that said, do not do this, and they went ahead and did this, that's going to be your proof when a regulator comes. And again, limit your liability. One thing to say about these last two slides is you can contractually protect yourself from liability, or try to, but it's not going to protect you from getting pulled into a suit. Because the government and private parties, they don't know that you have these private contracts with each other, right? They don't care. They're just going to, they see your name on a product or they see that you're responsible for sending them this email, they're going to come after you. The best thing that these contracts can do is really try to mitigate your exposure while you're in litigation, get you out of the case faster by saying, it wasn't me, it was them, I can prove it, this is, they owe me, they're indemnifying me. That's what you can do. But there's no foolproof way of staying out of litigation. People ask me that all the time. Contracts are not foolproof. And you only really know how good a contract is when you get sued and how well it holds up in court. So really good, these are good practices. And the last good practice is you hire a good attorney and they tell you what to do. And they can help you control the message and the messenger and manage your legal risk. Because affiliate marketing is a risky space to be in general. There's a lot of money to be made, a lot of instant turnaround. And sometimes you need to take a step back and say, okay, well, these are the things you can't do. And these are things I'm doing. Where do I fall in that spectrum? And what are the risks associated with these behaviors? I don't expect my clients, even though I tell them what the law is, to fully comply 100% with the law. I'm not going to say they don't, they 100% do, of course, if any regulators are listening. But what I try to explain to them is, these are the behaviors that are not okay. These are the behaviors that you're taking part in. Let's talk about what risks are associated with each and find out where you can fall in the spectrum and what level you're happy living with so that you can sleep well at night and not be concerned about lawsuits and, regulatory enforcement. That's my 18 minutes, I believe. Do we have questions? Yes? Go ahead. Sorry if it was fast. It was high level, 18 minutes. Have to get in and out.
Hi. A lot of our affiliates use banners to direct their traffic. I wanted to know, in terms of disclosure, do you have any creative ways, small text? It's something we're really struggling with now.
It's hard with that limited space. I sometimes recommend asterisks, like additional terms apply, click here, include. Hyperlinks are not really loved by the FTC, but if that's the best you can do, at least include a hyperlink to your terms. See here for more information, just something that alerts them to the fact that this offer is not just what it says on this banner. There's more to it, so be aware.
Okay, and also you discussed a lot about disclosure. It sounded like that was a lot disclosure of the offer. What about affiliate disclosure that they're receiving payment for their promotion? Are those within the same guidelines, or is that very different?
They're all part of the same guidelines, and that's a good question. Landing pages especially, you have to have affiliate disclosure. It could be in whatever terminology you want, but you need to make clear that you're getting paid for creating this ad and you're getting some money for generating leads. And absolutely, you need to have those disclosures. And that's why like the paid tweets are an example of hashtag ad or whatever. But landing pages especially have to have an affiliate disclosure.
Thank you.
Thank you. Anyone else? Well, if anyone has any more questions, feel free. I'll be at the Power Booth Station for another half hour, and my contact information is on there. Feel free to send me an email. And again, thank you. This is a really great crowd for the end of the day. I appreciate you all being here. Thanks so much.